Good morning, bonjour, tansi. I would like to welcome all honorable senators and members of the public who are watching this meeting of the Standing Senate Committee on Aboriginal Peoples, either here in the room or listening via the web. I would like to acknowledge, for the sake of reconciliation, that we are meeting on the traditional unceded land of the Algonquin peoples. My name is Lillian Dick. I'm from Saskatchewan, and I have the honor and privilege of chairing this committee. I will now invite my fellow senators to introduce themselves, starting with the Deputy Chair.
Good morning, Dennis Patterson, Senator for Nunavut.
Good morning, Senator Greenray from BC.
Good morning, Norman Doyle, Newfoundland, Labrador.
Good morning, Fabian Manning, Newfoundland, Labrador.
Good morning, Kim Pate from Ontario.
Good morning, Mary Lou McPhedran from Manitoba.
Thank you, Senators. Today we continue our study on what a new relationship between the government and First Nations, Inuit and Métis peoples of Canada could look like. We continue looking at the history of what has been studied and discussed on this topic. Today we are glad to welcome Val Napoleon, the Law Foundation Chair of Aboriginal Justice and Governance and Director of Indigenous Law Research Unit, Faculty of Law, University of Victoria. Professor Napoleon, you have the floor. If you could do about a 5 to 10 minute presentation, and then we will have questions from the senators following that. Please proceed.
All right, thank you. I'm honored to be here on these historic Algonquin lands. I want to begin with two quotes. One is from the recent Ministry of Justice Principles regarding the government relations with Indigenous peoples. And that quote reads, "The government recognizes that Indigenous self-government and laws are critical to Canada's future, and that Indigenous perspectives and rights be incorporated in all aspects of this relationship." The second quote is from the Truth and Reconciliation Commission, recommendation number 50, and that calls for the establishment of Indigenous law institutes for the development, use, and understanding of Indigenous laws and access to justice in accordance with the unique cultures of Aboriginal peoples in Canada. So I've been working on the substantive articulation of Indigenous legal traditions for some years. And one of the ways that I've begun to think about reconciliation is that it's rather than continuing a colonial asymmetrical relationship between Indigenous legal orders and Canada, that we work to develop a symmetrical relationship between Indigenous peoples and Canada, which includes Indigenous legal orders and Canadian legal order. And that means rebuilding Indigenous law across Canada so that it can do the work that is necessary for law to do in our societies. So we've worked in partnership with Indigenous communities to restate, research, and articulate law relating to lands, to water, to governance. We've been working with gender in Indigenous law and with human rights within Indigenous law. And it's the human rights lens that I want to use to frame this conversation that we have this morning. And the starting place is that all law, including Indigenous law, must do the work of law. Our societies had to deal with the messiness and complexities of collective human life in the past, as it does today, and that within our legal traditions are processes and substantive constructs for human rights, and that human rights within Indigenous law is an integral part of self-government in Canada. And the places where Indigenous law has been undermined, or where there are distortions or there are gaps, and in those same places where Canadian law has failed, are places of violence. And that violence is experienced by those most vulnerable, women and girls and others in our communities. So the task of thoughtfully rebuilding Indigenous law in those places is one that is the work in Canada today. If Canada is going to be multi-juridical, a legal pluralistic society, and one in which has symmetrical relationships between people. You know from the work that you do here and from your own lives, from your communities, how central Canadian law is to our understanding of ourselves and how we order ourselves, how we manage ourselves. And just take a moment and imagine if everything you knew about Canadian law disappeared or was rendered inoperable to your lives, what profound disorientation that would have insofar as your understanding of yourself and who you are in relation to the rest of Canada. That loss and the gaps of Indigenous law, that's exactly part of colonial history, where Indigenous law as a part of how Indigenous peoples manage ourselves has been rendered invisible or has been undermined. The work that we do to substantively articulate Indigenous law, and I've given an example of one of our reports and some of our other legal resources that we've created, they will serve as the foundation for the Indigenous Law degree program that we're proposing at the University of Victoria. So this is the first of its kind in the world, where people will receive an Indigenous Law degree and a Canadian Law degree over a 4-year period. It'll be taught similarly to how civil law and common law is taught at McGill with the trans-systemic teaching methodologies. And so, as an example, one could have Anishinaabeg constitutional law and Canadian constitutional law, perhaps Tsimshian property law and Canadian property law, Cree, Dene, and so on. And what people that go through the program will be able to do is to draw on the legal resources from more than one legal order in order to solve human problems and conflicts, which is essentially the work of law. The demands for doing this work are many. It's rigorous and it's complex work. Indigenous law is no more a quick fix for real human problems and complexities than Canadian law is, but it's an essential part of people being a people. The other aspect that's important to this work is that it be done on a regional or on a larger scale, because the Indigenous communities are very small and fracture the larger legal orders that they're a part of. So the scale in which the work has to be done has to consider those kinds of factors in order to ensure, among other things, the ability to deal with power imbalances and accountability. So we have, this is the work that we have been doing. We're particularly concerned with ensuring that not just lands and resources and water and so on are dealt with, but that governance in its fullness and ability to deal with human struggles and realities are a part of the rebuilding that we do. The other parts of the proposed Indigenous Law degree program include field schools. We would be taking 25 students a year into it. And it's one way to advance the work of rebuilding Indigenous law, and one way to to substantively work across Canada to deal with the kinds of experiences that people are now having. I want to give a small example of what happens when we don't do the homework with Indigenous law, and where our expectations and understanding of Indigenous law actually get in the way of Indigenous law itself. Recently, I was at a major national event, and there was an elderly woman who was asked to talk about the laws from her traditions, and she explained that she was part of an arranged marriage, having been at a very young age, and that throughout her marriage she had been disciplined, and that was the Indigenous law for her society. What's important about looking at that incident is to understand how, as someone who was asked to speak to Indigenous law, the way that she's going to find meaning and dignity is to frame her experience as lawful, as mattering to law. And the problem is that when we just have declarations of law without the background and the homework being done about the legal resources and principles and processes to draw from, law by declaration doesn't allow the kinds of accountability and fullness and problem solving that we need. A declaration of that similar kind about Canadian law wouldn't stand. People would know that there are legal resources, you pose a question, and you draw on those legal resources to come up with a response which is legitimate according to the people's legal order. And so what I'm talking about with Indigenous law is not going back in time, but looking at historic legal institutions and law, and looking at how those can be brought forward in a way that is legitimate, so that when people don't get their own ways, that they're able to uphold the decisions anyway. The kinds of thinking around human rights, Indigenous human rights, and in our work across Canada, what we found is that while forms and expression of law differ according to Indigenous societies, the problems we experience are universal. But there's also a similarity in terms of the kinds of aspirations that our laws seek. So just as Canadian law has aspirations of equality and fairness and the things that we aspire to in Canada, no legal order ever lives up to the aspirations, but it's important that a people have them. For Indigenous law, we found people's aspirations were safety, were inclusion, were fairness. We found that with Mi'kmaq, with Anishinaabe, with Cree, with Chilcotin, with Secwepemc, Coast Salish, Dene, and others. So there are those aspirations, and there are legal resources in terms of the oral histories, and we draw on those systematically and critically to inform the work that we do. Sally Engel-Mary, who is a really important legal scholar, has done a lot of work with human rights in the world. And one of the things that she has argued is that whether one understands themselves as being rights-bearing depends on their experience in the world and the legal institutions in the world. So their experiences with the law enforcement or courts or probation officers or whatever it is will determine whether they believe their experiences matter to law. So here's the thing, is that we have to ask that same question for Indigenous law. Are women's voices heard within Indigenous law? And if not, how do we rebuild in order to ensure inclusion? And so that's the kind of critique, that critical work that's necessary to rebuild those intellectual traditions.